It is time for the meeting. Can we now invite the administration to come in? First, I'd like to welcome you to the meeting. Please avail yourselves to the Legislative Council brief released by the Food and Health Bureau. The reference is FHCR 1/F/3261/92 PT 31, and also the legal notice, and also we have the Legislative Council brief prepared by the Legislative Council Secretariat. This is paper CB bracket 2 1427/17 to 18 bracket 02. And also on May 21st, the legal advisor of the Legislative Council wrote to the administration on the 21st of May with regard to the legal and other issues with regard to this regulation, and the administration will be replying in due course. The administration team members are in the list of the attendance list. I will now ask the administration to introduce the paper first before I'll invite questions from members. Mr. Fong Ai, please. Thank you, Chairman. Good morning, members. First, I'd like to tell you the background to this regulation. On the 28th of March, the Medical Registration Amendment Ordinance 2018 was enacted, and the number of lay members at MCHK has been increased from 4 to 8. 3 of those will be elected by patient organizations, and 1 is to be nominated by the Consumer Council. The ordinance empowers the Permanent Secretary of Food and Health to make election arrangements for these 3 members by subsidiary legislation. This will cover the election and also appointment procedure. This is exactly what is this regulation placed before members. When we scrutinized the amendment ordinance, members already discussed in detail the framework of this regulation, and the detailed arrangements were the subject of consultation with major organizations, and they have expressed support. The regulation placed before members is a result of our reference to Cap 161B. In other words, the basis for electing the 7 doctors. And we also have looked at other election procedures, and also we have consulted all the patient organizations in detail. Now I will take you through the regulation itself. Qualification of elector. Now, who can qualify as an elector? The elector must have the satisfaction of the Permanent Secretary to have fulfilled the following criteria, and that is, it has been registered under the Society's Ordinance for 2 years before the regulation is enacted, and it has always represented patients' interests and has conducted activities, and the principle of the organization is to represent the interests of patients, and also it must be recognized by the FHB or the Rehabilitation Council. These are the criteria, the objective criteria for qualification as an elector. Each elector can nominate candidates and can also vote, and a valid nomination must be supported by 5 electors. And in every election, every elector can only nominate 1 candidate. And as for the candidates, the person must have attained the age of 18 and he must be nominated. But then he cannot be a registered medical practitioner because this is to be a lay member. And he has been ordinarily resident in Hong Kong for the last 12 months. And he must not be subject to an order of bankruptcy, or that he has debt problems in the last 5 years, or that he has contravened election or corrupt practices related offenses in the last 5 years. As long as he does not belong to these categories, he will be able to become an elector. And the vote will be taken by mail, and each eligible elector will be entitled to up to 3 votes depending on the number of vacancies. And the greatest numbers of votes for the candidates will mean that those candidates will be elected, and the office will be for 3 years. If there is a vacancy and if the remainder of the term is less than or is not less than 1 year, the MCHK Secretariat will conduct a by-election. And if the remainder of the term is less than a year, we will invite the lay members of the MCHK to make nominations at the time, and the Secretariat, or actually the PS, to make the appointment.
As for election, it will be conducted every 3 years. We have a transitional arrangement for certain organizations. In the last 2 years, they have been operating. However, they have not been registered as a company or a society. So we have a transitional arrangement for such organizations, and they can also apply to be registered as eligible electors. After this piece of subsidiary legislation is passed, we hope that we can hold the election as soon as possible. According to our timetable, we hope that by the end of June, the regulation can be passed, and then in early July, we will start the electoral arrangement. And by the end of this year, we hope the election can be completed, and in early next year, the 3 lay members can become official members of the Medical Council. As for the commencement date, it will be appointed by the Permanent Secretary by notice published in the Gazette. We hope that this can be done by the end of June. We will welcome members' questions. Members, with regards to this document and the regulation, do you have questions? No? Mr. Chairman. Well, for this arrangement, so if patients' organizations want to register, they should have been operating for 2 years. And after the election, there may be new patient organizations. So after 3 years, what I mean is that they set up after the election, so they cannot take part in this election. So after the establishment and after they have operated for 2 years, they can apply for registration, right? So if I, Chen Hangban, set up a number of patients' organizations, however, they are all set up under a big umbrella organization. So these smaller patient organizations all have the same source. So what will you do with these organizations? Or you don't care as long as they are registered companies or registered society, then they will be recognized. When we designed the regulation, we have thought about this. Now, that is, in the past 2 years, they must have been doing things to safeguard the interests of patients, and also they have to be recognized by the hospital authority or the SWD or the Rehabilitation Council. The purpose is to ensure that they are bona fide operating patients' organizations. So they should be either under HA, Rehabilitation Council, or SWD, and they are really operating. So the establishment is not for the election. They are to help patients. So only these organizations are eligible. So when you define it, that is, it must be an organization safeguarding the interests of patients. And you talk about Rehabilitation Council. What do you mean by that? Now, under the Rehabilitation Council, there are 70 to 80 self-help organizations, and they are indeed helping patients or patients' relatives. There is already such a list. So in the future, if more organizations can be added, that is possible. But under the Rehabilitation Council, there is a network, so they must be recognized within that network. Other than the Rehabilitation Council, the SWD has also been supporting over 80 patient organizations in the past 3 years, so they are also eligible. Under HA, there are about 200. But of course, there are some overlapping situations. So there is such a system so that we can recognize these organizations. Dr. Pierre Chen, I would like to thank our assistant legal advisor. He has put forward some questions which are very, very detailed, so I would like to thank her first. So for the election appointment of lay members, I do not have any strong views. I try my best not to intervene in other sectors' elections. For our earlier discussions, well, doctors' elections have been protected by the basic law. That is, we should have professional autonomy. We do not want other people to intervene in our elections. So these are corporate votes. Just now, Mr. Chang Han asked some very good questions. That is, one person may set up several organizations. So for this election, would there be such a scenario that is overlapping? Now, if I belong to several organizations and these are all registered organizations, then I would have several votes. So what would happen if this is the case? Now, if an organization becomes an elector, it has the right to nominate and vote, and the organization is the basic unit. So we do not care whether they are overlapping members. A person may take part in different organizations, as long as these patients' organizations are really doing things to safeguard the interests of patients or represent the interests of patients, then we think it's acceptable. So the most important point is whether it is a bona fide organization helping patients. If so, it's eligible. So we have to look at the past 2 years. That is whether this organization has been doing these things. A follow-up question. Just now you mentioned that, well, you mentioned the HA, the Society of Rehabilitation, or the SWD. Now there are already patients' organizations under them. So they have the information of patients. And in your paper, you say that the organization should be safeguarding and representing the interests of patients. So how do you decide on this? There are no differences. Well, for safeguarding or representing the interests of patients, we try to adopt a broad view. That is, for example, maybe there are self-help or mutual help organizations. So all these would mean safeguarding or representing the interests of patients. Okay, no other questions. Okay, if there are no other questions, let's move on to the clause-by-clause examination. The legal advisor said that earlier on a letter was sent by her. So would you like to answer those questions now, or else you want to give us a written reply afterwards? Okay, later on, let's move on to the clause-by-clause examination. Mr. Fong. So for this regulation is to be made by the Permanent Secretary for Food and Health under Section 33, bracket 3A of the Medical Registration Ordinance. There are 11 parts and 1 schedule. Part 1 comprises Section 1 and 2. First, commencements. The regulation comes into operation on a day to be appointed by the Permanent Secretary for Food and Health by notice published in the Gazette. Now we hope that on or before the 29th of June, this can be gazetted so that the election can be conducted as soon as possible. 2. Interpretation. So for different terms in the regulation, their interpretations are set out here. Let's go on. Part 2, registration of electors. 3 lay members will be nominated by patients' organizations. So the secretary will take care of registration in accordance with Part 2. Section 3, announcement of compilation of electoral register. The Secretary must, within 1 month after the commencement date of this regulation, first announce that an electoral register is to be compiled for the purposes of the regulation and to invite applications for registration. And the Secretary must, before the 9 months preceding the expiry of the current term of office of the specified late members, A, announce that an electoral register is to be compiled for the purposes of this regulation, and B, invite application for registration. And Section 4, eligibility for registration. That is what organizations are eligible. An organization is eligible for registration if it meets the following requirements. Just now, Mr. Fong has also mentioned this. A, throughout the 2 years immediately before the end of the application period, it has been a company defined by Section 2.1 of the Companies Ordinance, Cap 622, or a society or a branch of a society registered or exempted from registration under Section 5A of the Societies Ordinance, Cap 151, and it has been carrying on activities to safeguard or represent the interests of patients. And its major principle is to safeguard or represent the interests of patients, and it is recognized by a reference authority as an organization that safeguards or represents the interests of the patients. That is HA, SWD, and Rehabilitation Society, or an organization recognized by the PS. For 1A and 1A, B, C, all these have to be met, right? Yes. Section 5. Application for registration. An organization that wishes to be registered must apply for registration in a specified form in accordance with the procedures specified by the Secretary. The Secretary must not process an application that is not received by the Secretary within the application period. So the Permanent Secretary will have to assess the application, and then a register will be compiled. The PS decision will be final. No problem. Please go on. Legal advisor. Please pay attention to 5.7. That is the determination by the PS is final. If an organization is aggrieved, it would have to seek judicial review. Okay, any problems? No, okay, go on. Section 6, Electoral Register. Well, it should be gazetted at least 1 week before issuing a notice of election. And it should publish the Electoral register by notice in the Gazette, inform applicants for registration, the results of the application. And the Secretary may amend an electoral register to rectify a clerical or printing error in the register or reflect a change in the particulars of an elector entered into the register.
Clause 7. It provides for authorized representatives. Since these electors are organizations, they have to authorize representatives to act on its behalf, and the authorized representatives have to act according to the decision of the electors. They must be over 18 years of age, and if this person has been authorized as a representative of that organization, he cannot become the authorized representative of another organization. If the Secretariat has received more than one appointment forms in relation to an individual, meaning that this person is the authorized representative of 2 organizations, then only the appointment form first received is valid. Any questions? Clause 8. The Secretary is authorized to make or determine procedures. Please continue. Now we come to part 3, Notice of Election. It provides for matters relating to notice of election and also the nomination period. Clause 9 provides for the details of notice of election, the number of vacancies that have to be filled, and that nominations of candidates are invited, and also who may be nominated as a candidate, and how the nominations can be made, and also procedures for providing for nominations of different numbers. Please continue. Part 4. Nomination of candidates. These are the detailed arrangements. First of all, Clause 10. Any person who has attained the age of 18 years may be nominated as a candidate at an election, unless the person is a registered medical practitioner, has not been ordinarily resident in Hong Kong for the last 12 months, and as Mr. Fong said a moment ago, he is an undischarged bankrupt, or within the previous 5 years has either obtained discharge in bankruptcy or has entered into composition or arrangement with his or her creditors, in either case without paying the creditors in full, or has within the previous 5 years has been convicted of having engaged in corrupt or illegal conduct in contravention of the ECICO, then these persons cannot become a candidate. Apart from A, B, C, D, and E, this person does not have to be a representative of patients' organizations. Is that right? It's just that the candidate himself must be, or the elector must be, a patients' organization, not the candidate. Well, Clause 11, nomination period, usually it is for 4 weeks. And if it is for a by-election or further round of election, there is no particular nomination period, because we want to make it flexible so that a by-election or a further round can be conducted as soon as possible. Clauses 12 and 13, how candidates are to be nominated. The candidate must sign on the nomination form to give his consent, and also that he is fully qualified to be nominated. And the nomination form must be signed by 5 electors at least, and that it must be sent to the Secretary of the MCHK within the specified period, and the elector can only make 1 nomination in every election. If there is a duplicate nomination, then only the first nomination form received will be regarded as valid. Please continue. Clause 14. After receiving the nomination, the Secretary of MCHK will vet the forms as soon as possible to make sure that they are valid. And then under the following circumstances, the Secretary may determine that a nomination is invalid. That is under Clause 4. Clause 15, withdrawal of candidature. A person who is nominated may withdraw candidature by giving to the Secretary a notice in the specified form not later than the day following the nomination closing date. Clause 16. A person who has been validly nominated as a candidate for an election is disqualified from being elected as a specified lay member if the person becomes a registered medical practitioner, becomes bankrupt, is convicted of having engaged in corrupt or illegal conduct in contravention of the ECICO Cap 554, or commits a prohibited practice in the schedule to that ordinance. Please continue. Chairman, we come to Part 5. This is about result of nominations. Clause 17. The Secretary must issue to every elector a notice of result of nominations within 45 days. And clauses 18 to 20 state the 4 scenarios after nominations have been made. First of all, if the valid nominations exceed vacancies, then we must have a competitive election, and the arrangement is in clause 18. Secondly, if the number of nominations is equal to the vacancies, then the Secretary will declare the candidates as having been returned ipso facto. This is clause 19. And the third scenario is if there is no candidate who is validly nominated, the Secretary will have to announce a further round of election. This is in clause 20. If there are more vacancies than valid nominations, then the Secretary will declare the validly nominated candidates returned as ipso facto, and at the same time a further round of election to fill the remaining vacancies, whether it is the general election or a by-election. And if the remainder term is more than 1 year, then if we have to conduct a further round of election to fill the vacancies, and the Secretary of the MCHK will start the further round of election as soon as practicable. Please continue. Thank you, Chairman. Part 6. This is about a detailed arrangement for polling. From 21 to 27, these are for polling and counting of votes. Every elector will have 3 votes up to the number of vacancies. If there are 3 vacancies, then the candidates with the most votes will be returned. This is the same as for medical members. And then it is up to the MCHK to decide when to give notice for submitting votes. And clause 22, the Secretary will issue to every elector a polling notice, a ballot paper, and a declaration form. Clause 23, it says that votes are to be cast by postal ballot, and how votes should be filled in before they can be regarded as valid. And the authorized representative must mail the polling paper together with a declaration form to the Secretariat, and the postal chop will be regarded as proof of validity. Clause 24. If the elector has inadvertently marked or spoiled a ballot paper and another ballot paper or declaration form has to be issued by the Medical Council, this is the arrangement. Clause 25. Counting of votes. That it must be within 30 days after the end of a polling period. The Secretary will notify all candidates of the counting of votes, and the candidates can be present at the counting of votes. And the chairman and other persons the chairman considers to be appropriate can also be present at the counting of votes. Clause 26. The Secretary can reject ballot papers in certain scenarios. Clause 27. The MCHK Secretary can delegate power in relation to polling. This can be delegated to a Deputy Secretary or any other person in the Secretariat. Clause 28. The candidate with the most votes will be returned, and the candidate who has obtained the highest number will be announced as elected. If a poll is conducted to fill 2 or more vacancies and 2 candidates have the same number of votes, then a ballot will be conducted by the Secretary to decide who is elected, and the person whose number is drawn will be announced as having been elected, and the chairman of the MCHK must be present, and any other persons who are present or not present at the announcement will not affect the validity of the announcement. Clause 29 and Clause 30 regulate situations where there is death or disqualification of candidate before or during the polling period. Clause 29. If this happens before the polling period, then the Secretary of MCHK will issue the notice to the relevant candidate that he is no longer a valid candidate. But if this happens during the polling period, then according to Clause 30, the election will be countermanded, and a further round of election will be conducted to fill the vacancy. And the Secretary will have to specify or issue a notice of election as soon as possible, and must specify in the notice of election with regard to the reason for countermanding the election. If this happens after the polling period and before the declaration of result, then Clause 31 stipulates that the procedure will not be terminated. If counting is not completed, it will continue. And if that candidate will have enough votes for him to be elected, then the election will be countermanded for a further round of election to be conducted. The Secretary must issue a notice of election for the further round of election as soon as possible, and must specify in the notice of election the relevant matters and reason for countermanding the election. If after the counting of votes is completed, the votes cast for the relevant candidate are not sufficient for returning the candidate at the election, then the one with the most votes will be returned. Please continue. Thank you, Chairman. We'll come to Part 7, Result of Election. Clause 32, it says that the Secretary will gazette the result of election and will issue to every elector a notice of the result. Clause 33. Starting from the gazetting of the result, if within 3 months the specified lay member fails or refuses to assume office, then the candidate next in line will be qualified. But if there is a tie, meaning that there are 2 candidates with the same votes, then the Secretary will conduct a ballot to see who should take up the vacancy. And then the term of that stand-in will be the same as the term for the original elected candidate. Part 8, Documents and their disposal. These are technical clauses. Part 9, Election Petition. Clause 35 and all the way to Clause 39 state the details of election petition, including the grounds and who may petition, the respondent, who he is, and also the time limit. According to Clause 35, the election petition can be on the following grounds. A person declared to be elected was not duly elected, meaning the person is not qualified for nomination. The person is disqualified. This person has committed a prohibited practice or by or in respect of the person. That this person has committed a prohibited practice generally or in respect of the election. And then another ground, a person determined to be not validly nominated as a candidate under this regulation should have been determined to be validly nominated, or material irregularity occurred in relation to the election. Now, who may petition? This can be made jointly by 5 electors, or by a validly nominated candidate, just one, or by a person determined to be not validly nominated as a candidate at the election. Clause 37. Now, who is the respondent to an election petition? And Clause 38 states the time limit, that it must be presented within 30 days from the date on which the result of election is declared. Clause 39. How election petitions should be presented. It must be served on the chairman of the MCHK, and who is the petitioner and what is being petitioned about. The copy should be sent to the respondent. Please continue.
Clause 40, procedural matters before hearing. Now, if the petition is not submitted without grounds or without following the procedures, then the chairman may dismiss it. And the Secretariat will, in accordance with 40(3) to 6, arrange for hearings, review the procedures and results. And the petitioner and the respondent would have to follow all the procedures. Clause 41, withdrawal of election petition. 42, the details concerning the hearing procedures. Clause 43, determination of council. After the hearing of an election petition, the council must determine whether the ground of the petition has been proved and whether a person declared by the secretary to have been elected that the election was duly elected. If it determines that a person was not duly elected, determine whether another person was duly elected in person's place, and make any other determination in relation to a person as it considers necessary, and the determination is final. The legal advisor has some questions. I would like to remind members for 43(2), it says that the medical council's determination is final. So if people feel aggrieved, they also have to seek judicial review. Clause 45, successful election petition does not invalidate previous acts. That is, acts done by the person in the execution of his or her office as a specified lay member before the determination are not invalidated by the determination. Clause 46, how to fill vacancy if an expired term is less than 1 year. In the 2018 Medical Registration Amendment Ordinance, it states that if the unexpired term is less than 1 year, and then the vacancy must be filled as soon as possible. The Secretariat would have to invite nominations, and the nominees should be able to represent the interests of patients. And a judgment would have to be made as to whether the nomination is valid. And if the nominees' number is more than the vacancy number, then a meeting will be held to decide on that. So at the meeting, lay members, now if the chairman is also a lay member, then he will be included, but only lay members will be able to vote. Any absentee will not affect the effectiveness of the election. So if two candidates have the same votes, the secretary will draw lots to decide as to whom is elected. At the same time, they will decide whom is elected. The secretary would inform the permanent secretary about the election results, and he would appoint the elected candidates as lay members. Here you say that lay members are to nominate. So this is not about this 4. It includes all the 8 lay members, right? And the PS will decide as to whom is appointed. Now, if there is an extreme case, supposedly, I don't know what happens, if all the lay members resign, and there is no lay member, then how can the nomination happen? Well, for the original 4 lay members, they were appointed by the government. We believe that they won't resign at the same time, but that may happen. Mr. Fong, this involves the a vacancy of which the term is less than 1 year. And if the 4 appointed lay members resign at the same time, then the government can appoint them as soon as possible. The government's appointment procedures can be done first, and after that we will follow these procedures here. So for this vacancy, it must be nominated by lay members. If all the lay members resign, then the government would appoint 4 lay members first, and then they would do the nomination. Please go on. Part 11, transitional provision. As Mr. Fong said just now, for Clause 47, it is about compiling the first electoral registered. Now, for these organizations, they have been operating for 2 years or so, but lately, they registered as a company, a society, or a branch of a society. So they have to meet all the descriptions in Section 4(1)(a), 1(a) or B. Then, if they have not been operating for 2 years, the permanent secretary can still allow them to be registered as electors. So this is a transitional arrangement. The last part is the schedule. This is about prohibited practices. For example, bribery or intimidation concerning candidacy, false statements concerning withdrawal, etc. So if these are breached, a person cannot become a candidate. So when it comes to clause-by-clause examination, we will end here. Members, any questions concerning the clauses? If not, then we have completed the scrutiny of this regulation. The government still owe our legal advisor a reply. We have sent in questions in writing. Please give us a reply. So we are done with our work. After receiving the reply from the government, it will be circulated to members. If members think there is a need for another meeting, we will convene one. If members are satisfied with the government's reply, we won't have another meeting. But we need to apply for extension anyway. It will be going to the House Committee on the 8th of June. So 8th of June, House Committee. If members are to make amendments, the deadline is 12th of June, and then this will go back to the Council on the 20th of June, and then the whole scrutiny will be completed. If the government will make amendments, then we will have to hold another meeting. Mr. Fong, I would like to talk about the commencement notice. If it's after the extended date, if then in accordance with the medical registration ordinance, we will have to issue a commencement notice. We hope that we can do it by the 29th of June. And it will also be subject to negative vetting, and there will be a 4-week arrangement. But we will start with the electoral arrangement. We won't wait for the end of the 4 weeks. I think members would agree to that. That is, the work should be done as soon as possible because it will take time to do the electoral arrangement. No questions? Then we will wait for the government's answer, and then we will decide as to whether another meeting will be held. Thank you.